Thank you for attending this Garden Court webinar on defending international child abduction. This webinar is produced by the Garden Court Family Law Team. I am Maggie Jones. I have to say I'm now the longest standing and oldest member of the family team at Garden Court, and I deal with a range of cases involving children, including international abduction. The family team at Garden Court is a very strong and vibrant team with a huge range of talent and expertise. And we are very lucky indeed to be part of the chambers with other teams specialising in a range of other areas, including crime, immigration, housing, human rights and civil liberties, so that when we have queries in relation to those areas, we have people that we can immediately go to. And that is extremely important in a range of cases, including child abduction cases. The object of this seminar is to provide a very straightforward and practical guide to defending child abduction cases. Child abduction cases both under the Hague Convention and under the inherent jurisdiction where the other country involved is not a signatory to the convention. And of course, these cases are very significant because in many of them, the issue of where the child is going to be will dictate what relationship that child has with each of the parents in the short, medium and long term. They are all heard in the High Court, and there are complications about the immigration rules of other countries involved, and indeed about our immigration rules, which are forever changing and likely to continue to change. And in some of these cases, information is needed from immigration practitioners, and expert evidence is also needed. So as I say, the aim of this seminar is to provide a straightforward and practical guide to child abduction cases as is possible in defending cases where there's grave risk of harm, in particular responding to claims of domestic abuse risk if the child is returned, cases where the child objects to return, and complexities where immigration issues arise. We have, in fact, 2 speakers tonight. There were going to be 3, but Natasha Shatunde unfortunately has been unable to attend. But our speakers tonight are, first of all, James Holmes, who I have to say is a fantastic member of our family team. He's been with us for about 10 years now. He deals with public law, children matters, court of protection matters, as well as child abduction matters. He has a particular expertise in cases involving female genital mutilation. He has a huge breadth of knowledge. And I should also say he's a fantastic member of chambers and treasurer of chambers, and sits as a tribunal judge in special educational need cases. Our second speaker is Rehab Jaffer, who has a very wide-ranging knowledge and practice. She has been with us since pupillage. She did most of the immigration work in pupillage with us, and now practice is predominantly in wide-ranging family cases, but has the immigration expertise as well, which is an enormous advantage, and is well qualified to deal with overlaps between immigration and asylum cases and child abduction cases. So I'm going to hand over to James first of all, and as I say, if you have questions, then there will be the Q&A box, so please put those questions in there. And if we are unable to deal with all of those within the terms within this seminar, you can always come back to us via our clerks. So over to you, James.
Um, Thank you, Maggie, for that introduction. So, as you will see from the slide that I will be discussing with you, is that international child abduction. There are normally is under two aspects of the matter. That you have proceedings that get brought under the 1980 Hague Convention, which are all the signatories to the Hague Convention, and that has come into effect in the law of England and Wales under the Child Abduction and Custody Act 1985. Or for all those cases that do fall outside of that, the only avenue of recourse that you have would be under the inherent jurisdiction. And I will speak about both of those this evening. That one point I just make here that we used to talk about Brussels 2A, and you will see in a number of authorities and that referenced, and that unfortunately as of the 31st of December, we no longer need to consider that because of Brexit. That one point of observation is that there are, as those who do practice it more regularly, there's central authorities in all signatories to the Hague Convention. Those are the central organisations, the central post box sort of element, that where any applications that do come in to this jurisdiction of England and Wales get sent. And just as a point of observation is we have one in England and Wales, there's one in Scotland and Northern Ireland, those all being different signatories to the Hague Convention. As I think Maggie has already touched upon, we have proceedings of always in the High Court. Moving on to the next slide, I just wanted to reiterate that Article 1 is of the convention cases, is the object of the convention, which was to secure the prompt return of children wrongfully removed or retained in any contracting state, and to ensure that rights of custody and access under the law of one state are effectively respected by the other. And most of those who practice in the area, I think the intention was cases should be concluded within about 6 weeks of issue. That is not something that actually and realistically happens, despite as much guidance and encouragement by the courts. Those that practice also will know, and that there are 4 grounds to defend such a claim. I will be not speaking with all 4 of them, but you have settlement, and that is if in the situation of if there's more than 1 year has passed since the child has been in the jurisdiction, that is a defence, and that is no more or no less than 365 days in this jurisdiction. You then have consent or acquiescence, namely when it is alleged that the other parent with custody, rights of custody, that could also be a court, has agreed for the removal from that jurisdiction to ours. That you have the harm and intolerable situation, which is shorthand for the grave risk if that child, or he or she is to return, would expose that child to physical or psychological harm, otherwise place that child in an intolerable situation. And finally, there is the child objections, that being that child objects to a return. Moving on to the next slide, dealing then with the question of grave risk. The principles have been summarised, and there's numerous authorities on this. One I find quite useful and is quite cited regularly is a summary provided by McDonald J in the case of E versus D return order 2022. That sets out at paragraphs 29 to 30 a very good summary for those who just need to grab hold of it quite quickly in a succinct matter. That it is quite what I'm going to highlight. I won't read it out. The key bits to this is that the words of Article 13 are plain and don't need to be elaborated or glossed. Us lawyers love trying to add to that, but it has been quite clearly and consistently said by the courts we do not elaborate or want to see to add gloss to that. The key bit also then is that the burden lies upon the person opposing the return. That is generally the person who will most times always be the person who's brought the child to this jurisdiction. Burden is placed upon them. That is no special burden. There's no burden increasing due to the severity of the risk or the seriousness of the harm, it is the standard civil burden, and that we need to be mindful of that. And that we all have to be conscious that the risk to the children have to be grave, and it is not enough for the risk to be real. It must have reached such a level of seriousness that it can be characterized as grave, although grave characteristics the risk rather than the harm. And I'll give you an example in a moment. Moving on to the next slide, is that then it goes on to the other 2 points, which is the words physical or psychological are not qualified and do not gain any colour or alternative. And intolerable is very strong words. And Article 13b looks to the future. And I think that's an interesting thing, and the cases discuss this, is it says to look at the future, to look at what it would look like for the child if the child was returned to his or her home country. That goes to where the question of protective measures, which I will talk about shortly, also arises. That though means you have to look in the past to look going forwards, but also it goes relevant in respect of situations that if you can say there's been a change, there's things that could be done to mean the situation would not be the same on the return, that would address that. And one point that is also mentioned, and we all need to remember, is and deals with this point I was just discussing, is whether there is a need for fact finding. And I think the Supreme Court has been very clear that the approach to be adopted in respect of the harm defence is not one that demands the court to engage in a fact-finding exercise to determine the veracity of the matters that are alleged, which is a very difficult thing to explain to clients when they are saying, I need to prove this, I want to fight, and to show that it's not true, that the courts really are what they approach they take is that they assume the risk of harm is at its highest, and then if that risk meets the test under Article 13b, the court then goes on to consider the protective measures, which we will do in a moment. But that is when it becomes difficult to explain. But what it is also clear from the authorities is that doesn't mean the court shouldn't be looking at the credibility of those issues and whether that can be done on looking on a paper-based exercise to seeing how credible matters are. So I think it's a balance. It doesn't require clients to go in the box, but if there's evidence to say that's incredible or not possible, those are matters that the court should still be considering in this process, and that is not something the court says shouldn't happen. So going on to the next slide, I'm talking about how we establish the grave risk of harm. And that it was clear in the case of Rias, Abduction 13b, so this is on the next slide, you will see in a moment, is that as the case law was very clear to establish a grave risk of harm, the court must assess, as it says here, the court must assess the nature of the risk, the likelihood of the risk materializing, and the consequences of the risk materializing for that child. And that is a three-part aspect of looking at grave risk, and as how a court should actually and properly consider it. It was explained in Rias, the key question is, and I'll read this bit because it makes it to assess, is what is likely to happen if the mother and A were to return? Is the likely effect on the mother's mental health sufficient to establish a grave risk that A would be exposed to physical or psychological harm or otherwise placed in an intolerable situation? As referred to above, this requires consideration of the nature of the risk, the likelihood of the risk materializing, and the consequences of the risk materializing. So putting that into context with an example, and this was in a case of YM versus ML, a 2025 case, is that was a case in respect of when Mr. Nicholas Allen, King's Counsel, sitting as a Deputy High Court judge, was considering the risk of psychological harm to a mother and the risk of return to Australia and the impact that would have. It was accepted, the risk, because the mother had a diagnostic criteria of moderate depressive episodes, that the risk of return would be impacting upon her depression. Then what the court had to do is found what that risk was, but look at the likelihood of that risk happening and the impact. And when the court was looking at that, it was reported, there was expert evidence. That report said it was well managed with medication, that the prognosis was good if she continued with the medication, and the expert accepted the impact of the return could be partially mitigated and managed if she continued to take the medication. Therefore, in that case, the risk, in case of any sort of psychological harm, is the risk is that if it goes back, her anxiety will get worse. That will then impact upon her ability to meet the needs of the child, and therefore have a negative and risk of harm to the child. That in that case, it was decided that actually the risk would happen. There's a risk could happen, but the grave risk was not satisfied, because the judge was satisfied that it would never get to a point that she would get so unwell that she would not be able to meet the needs of her child if she was to return. So therefore, that's an interesting example of going, when trying to establish a grave risk, working through the logical process, and where actually, if you were trying to defend a return, trying to have enough evidence before you to saying why actually it's not just because she has depression, but this is the likely impact, this is why it can't be managed. And this, I think, was an interesting example of a case when the mother had come from a country that has a good health system. If you were going back to a country, returning to a country that didn't have the ability to manage the system of her mental health that well, you'd have been in a very different argument, and it would have been quite easy to establish the grave risk of harm. So moving on to the next slide, we then have the question of domestic abuse. And it's always been accepted that domestic abuse on its own is sufficient to establish a grave risk of harm for a child. And I think that's not an obvious point. What is becoming more and more obvious and more aware nowadays is the fact that the courts are more astute to the fact of the court must be astute to recognise that there's conduct as well, and that those patterns can be of controlling and coercive behaviour. That was mentioned in the case of AM 2021 EWCA Civ 1998. The Court of Appeal said that we all are more aware of that practitioners are now more conscious of Practice Direction 12J, and that though that is as applicable to situations of abduction under the Hague Convention as any matter before on domestic legislation. And therefore, that is where it's useful to, when trying to establish grave harm, to remind the Court of Practice Direction 12J the definitions that are contained within it, including coercive behaviour and the controlling behaviour ones that I have quoted there. And I think that is the point when looking at the cases and reminding the courts to do that to look at it in a proper context, that we now need to apply 12J. Then the other aspect of grave risk of harm that I want to now talk to you about is the unsafe country. I call unsafe country, so I think it's applicable to more than just wars, but I think where it is currently very applicable at the moment is in respect of the situation in Ukraine. There's been a number of cases on this as a risk, parents abduct and bringing children over and then saying they can't return. The first case was a case by Mr. Justice Williams, the case of Q versus R, 2022. He stated, and I think he warned, that we all had to be very careful of avoiding generalities, and insofar as possible evaluate the particular risk to this particular child in a return to this particular area. Rather than apply a general or broad brush, one must apply a rather more detailed and finer brush to this. Because in that case, the mother was trying to say, just can't return to Ukraine, it's too dangerous. And the judge, Mr. Justice Williams, on that case said, look, we had to look at the part of Ukraine where the child was actually having to return, and how that impacted on the situation and the decision-making process. There have been numerous other cases. There have been about 4 or 5 ones I found, reported cases, but the other one I wanted to take to, which is of useful interest and contrast, is the case of Rien, which was 2024. It was a case before now Mr. Justice McKendrick. That case, the mother was trying to seek that child could not return not only because of the grave risk of harm of the war, but other matters. The other defences didn't stand in respect of her own risk of domestic violence, because the judge found there was a system in place to safeguard her in Ukraine. And the question for that was about the war. And as you can see, in the first iteration of the case was the judge said the child could not return because the father wanted to return to a dangerous part of Ukraine, in the sense that the town and hometown they were from was within very close to the front line. And Mr. Justice was like, it's obvious that it's a grave risk. But due to the facts of the case, the young child wanting to return to see his dad, family, and friends, what Mr. Justice McKendrick did, as was highlighted, you can do in such cases, in the case of VGP, is adjourn a case for further evidence to be filed. And that is what Judge McKendrick did. He sought that to be filed. And then in those cases, there was evidence filed that the father could move to a different part of Ukraine. And in those circumstances, that is what he did. And then the judge ordered a return. So that's useful not only for this sort of case of the war of the Ukraine, but in other cases when it's a little bit of evidence is missing, you can ask the court in certain circumstances to adjourn to enable that evidence to be filed. So once, if and when a court or someone is satisfied there is a grave risk of harm, the next question, as I said, is this, and the second part of the test is the question of protective measures. Protective measures, I think, is it's quite a difficult and always sometimes not well evidenced part of applications, because as I think Mr. Justice Cobb, as he then was in the case of RT, said, protective measures need to be what they say they are: protective, and they have to be effective. It is no good enough to say, oh, there's these measures that we could do. We could, like the police, there's the local police station, or the local police service, or the social services. But unless they are to be an effective remedy to safeguard from the risk that has been identified, they're not really worth any more than the paper is written on. And what Mr. Justice Cobb did in RT set out 5 short points that need to be considered when looking at protective measures. That you've got to look at the question of address, and this is the thing where people get wrong, address them at the beginning of proceedings. If you're going to claim there are protective measures, or the other side are going to, you need to start identifying the evidence you need and the information you want. That is where's the importance of that as a case management direction. The court then needs to be satisfied they'll have all the information before it to say that they are effective, including the question of undertakings, whether they are an effective remedy. That there are many, there's a question whether they're effective in this jurisdiction as well, but especially if you are leaving country, can they be mirrored? Can they be put in place? And as he highlights in the case, the distinction between protective measures and a soft landing, safe harbour provisions, on the basis that you can make sure there's a safety when they get there, land, etc. But it's more than that. It's where they go, what happens thereafter. And one point to make, that what is also needs to be established is that, and another point to remember in respect to protective measures, what you can't say if you are the person defending the application to return, try and allege that the other country is not a sufficient protector, that there are questions about their system. As McDonald says in GVD, it is a well-established that court should accept that unless the country is proved, the administrative, judicial, and social service authorities of the requesting state are equally as adept in protecting children as they are in the requested state. So you can't say it is better here than in France, for example, unless you had concrete, clear evidence to say why not. Points I just make as observation about protective measures is that, firstly, the time it takes for them to be put in place. I've read about a case recently that, as with our country, the High Court goes on vacation, but in that country they go on vacation for 6 weeks and they don't do anything. I think it was Portugal, if I remember. There's 6 weeks they close. So if you are trying to send them back over summer holidays with protective measures, you need to know that actually can't go back until probably October, until things are all back up and running again. You need to be conscious of the cost of putting in place the protective measures and who should pay, whether that is you, the other party, or where that money comes from. I put the question of the length of the time protective measures should remain. The reason I raise that is everyone who practices and will read is that the good practice guide states that protective measures are not to be imposed as a matter of course and should be of a time-limited nature that ends when the state of habitual residence of the child is able to determine what, if any, protective measures are appropriate for the child. It's run as an argument quite regularly that, okay, it's only up until the next hearing starts. That hearing will be in a month once they get back. We only need to make sure there's enough money in place for a month. That is discretionary. There are cases, and there are numerous cases, and some more recent ones, when judges are saying, look, actually, fine, that's right, but we need to have grave risk. We need to make sure that the person, especially if there's financial issues, is not going to be at jeopardy within a month or so returning. And judges are saying now that I won't return a child unless you give me 12 months of assurance or 6 months. And it's very much a factual case on case specific decision. But that is a question to not, it's not just look at the first thing. You can ask the judge to extend it for longer. And that, again, putting on the other point, the ability of the returning party to secure representation in returning country, funds and so forth. And the bottom one, the ability of the returning party to return with the child. Not only is that physically, practically, financially, but there are immigration questions that need to be considered as well. Dealing with the next ground of child objections. And I always find this when I first started, how are you going what to deal with how if a child is saying, I don't want to go back, what do you do? But firstly is that where defence is raised, CAFCAS in the High Court will do a report. They will interview the child. That doesn't mean the child is added as a party. That is not what is intended. They are generally and quite regularly represented without being made a party. Where do you go when you are first looking at these cases? Reminding yourself of the authorities. It's reminded the seminal authorities are in REM and REF, and that's where the law is. That the question that arises when considering a child's objection is whether the child has attained an age and degree of maturity at which it is appropriate for the court to take account. And it is also clear from the REM that the court and party should avoid subtasks, technicalities of all sorts. Again, the language is simple and clear, and we shouldn't be adding to that as lawyers. We apply the law as it is written there. And a useful summary of the relevant principles is set out in REC, which include that is appropriate to break down the exercise in two parts. That is the gateway stage and the discretion stage. The gateway stage, again, broken down even further and making sure the child actually objects to being returned, not just going back, actually returning to the country, and that the child has attained an age and degree of maturity at which it is appropriate to take account of his or her views. It's a low threshold that the views have to amount to an objection and not just a preference, say I just don't want to go back. That's not necessarily an objection. And the children's views are not determinative of the application. That's a key point. Just because the child says no, there are other factors that have to be added and considered when looking at this. And that the court also has to have regard to the provisions in Article 12, that is respecting the child's views. And that if you do get to the discretion stage, you then look at the case of REM, which sets out the approach. A useful point. I was thinking, I can tell you all that law, but you will be going, how do we apply this? And what do you have any pointers in respect of this? This is not an exhaustive list, but these are the things to be considering when you are presenting with a child that is objecting. Again, as I said, does the child's view expressed by a child constitute an objection? In the sense of when you were looking at it, is it just, I want to stay here. It's not really an objection, or is it just more expressing a preference or a preferred outcome? And that's not necessarily an objection. It's quite clear to understand when guardians and people are saying there's an objection, what is actually being said. And again, is it an objection to the return to the country or the care of the parent? Because sometimes the young people, the children are like, if I go back, I have to go live with daddy. I don't want to go and live with my dad because that's what I don't want to do. Not that I don't want to go back to go and live in Poland or Spain or Portugal or Australia, it is the belief that child thinks they're going to have to go and live with their dad. When you were looking for evidence to look at undermining a child's objections, has the child been expressing those concerns or worries to other people? That's a useful thing to look at when looking at how strong the objections are. And also what about the maturity aspect. It's looking for things that, is the child a bright child, thoughtful child described by the school, or are they saying that actually they're impulsive and people pleasing? And that helps you work out is whether the view's a strong one or not. Looking for words like maturity, commensurate to their chronological age, and that when also looking at is it the child making views that because of they have a better lifestyle in England than the country they were removed from, and then that is a thing that undermines their expressed views. And likewise with, are they just mimicking the views of partners, siblings, or other family members? So these are all things to be considering when looking at a child objection. What can I challenge this on? What am I supposed to be putting evidence before to show it's a good, strong view? So that is kind of the description of how it all applies to Hague cases. I just want to touch now upon the other aspect. If they aren't Hague cases, the inherent jurisdiction. And the inherent jurisdiction will need to be invoked in all cases that when it doesn't apply. The law that is applicable, and this is the question, when people go, oh, it's the inherent jurisdiction, it must be really, really complicated. It isn't. As being reminded, and I identify a recent case that confirmed this, is that the law that is applicable to such an application is only Section 1 of the Children Act. We all know that, best interest of the child or children. That is simply the test that is being applied. That there's a few things that are added to it, but it's nothing more complex. There's no habitual residence. There's no defence under grave risk of harm. None of that. It is Children Act, Section 1 of the Children Act. And that recently in the case in 2022, Lord Justice Moylan said there is no need for further guidance. People keep asking for further guidance because Re-J and Re-NY, both Supreme Court, both how decisions of the Supreme Court contain the relevant sufficient guidance on the subject to the purpose of determining an application for the return of a child to a non-convention state. It is a welfare determination, and that is what is balanced there. So when anyone ever says to you, and you are against anyone goes, oh, it's more complicated than that, just point them out to be A and B. But what is added to the Section 1 criteria, but this is very simple again, the degree of the connection of the child with that country. What is their home country? So there was a recent case I'm coming to, when a judge got taken astray, but the home country is similar to a habitual resident, not habitual resident, yes, habitual resident where the child lives and where it's living. Home country is the connection, and the length of time they've spent in each country, depending on the facts, there's a question about legal systems and also the impact of any decision on the child's primary carer. Those are the four things that are added to as key points that need to be considered. And this is the recent case I wanted to discuss about the inherent jurisdiction in cases, which brings everything together and makes it quite simple in one aspect. In the recent case of Rio, which was before the Court of Appeal, it clarified and addressed three quite areas I thought were quite useful. What is the actual test? What happens if a parent says, I'm just not going back? And the impact of DV on such applications. Mr. Justice Cobb, I think it was one of the last cases he did before he was formally elevated to Court of Appeal, said that an application for a summary return of a child to a non-Hague country is to be determined simply and straightforwardly by what is in the child's best interest, and that a judge considering a non-Hague application must undertake a swift, realistic, and unsentimental assessment of the best interest of the child, leading in proper cases to prompt return. Sounds very familiar to a Hague case or the intention of Hague cases. That goes to Ben's point, dealing with the point about swiftly. And this is where the balancing exercise of how much information, whether it's a fact-finding exercise or needed, how much information they need, because it's supposed to be swift. And that is a key point from rising from that. We all are presented with the mum, or it'd be a mum. I keep using mum and father because generally most cases I've had are the mother brings a child here and is returned back to another country where the father is away. There are the cases when the husbands do that as well. Those are less of my area that I deal with. It's in relation to what to do. Recent case highlighted that the court will always, and this is a different case, the court will make a reasoned assessment of the degree of likelihood of that parent not returning. Relevant considerations will no doubt include overall circumstances, the family history, any professional advice, and goes on. But the quotes again in that case, courts of understanding reluctant to allow primary care to profit from their own wrong. It's always, I always find that's a use that says, but how many times have we had a parent say no, and the judge says they're not going back, so we're not going to order it. VOs was useful and interesting because Mrs. Markham's King's Counsel, was sitting as a deputy High Court judge, found that Mother actually was making a tactical decision, that she was deliberately doing, and actually she would return, and also it didn't matter because the father could be the primary carer. So in those circumstances, on the facts of that case, it didn't matter. The parent was refusing to return, and therefore the judge ordered the return at the High Court, and also the Court of Appeal said valid, doesn't need, that's not an issue, not a ground. In dealing finally with final part of this is in respect to domestic violence, and the question really for the Court of Appeal was the parent had made very serious allegations before, and then withdrew them. And those allegations included rape, sexual assault, and I think potential strangulation, if I remember correctly. But she withdrew because she said actually that makes no, as quoted, that made no impact upon the welfare decision she was asking the court to make. So they withdrew them and then got to the hearing, and they the court dealt with them quite quickly and said they weren't necessary to be investigated. The matter was raised as a ground of appeal before the Court of Appeal. And the Court of Appeal concluded that actually they didn't need to investigate those. It wasn't something that needed on the test. And it was useful to highlight that the Court of Appeal highlighted that actually Practice Direction 12J does not apply to inherent jurisdiction applications, or those particular ones, but in practice will always be treated as applicable. The reason that being is that the orders you are asking for an inherent jurisdiction to return is like a specific issue order, or specific issue order. Therefore, you have the right to say 12J applies. So that is how the Court of Appeal said it happens, and it all implies within the matter. And that the court also specifically redrew the attention to paragraph 37(3) of H and N, which stated that careful consideration must be given to Practice Direction 12J, and it goes again to the necessity test. So the standard approach that we take, or the approach we now take through the guidance through H&N 12J of domestic violence, applies equally to any inherent jurisdiction claim that you have, and therefore the courts have to be conscious of that as a issue and the welfare interest of the child when is returning, and considering a return to a country that is a non-Hague country. As Meg said at the end, we're going to be giving some questions, and we'll answer your questions, but also give some examples of cases we've done. But I'm now going to hand over to Rehab, who's going to just talk about the immigration issues that you can encounter in such cases.
Thank you, Rehab. Thank you, James. We'll now go to Rehab. Okay.
Thanks both James and Maggie for that detailed breakdown of such an extensive area. Of course, where we have international child abduction, there may well be parallel immigration and asylum proceedings. There has been some guidance issued to both the Home Office and family practitioners on how these cases should be case managed. But firstly, if a decision has already been made by the Immigration and Asylum Chamber, it doesn't necessarily bind the High Court when dealing with child abduction cases. It will be important, however, to be aware of whether an asylum application has been granted, whether the child or parent is a recognised refugee, and whether there is any overlap between immigration findings and any proposed return. So the 2021 Supreme Court case of G&G confirms that the High Court can decide and make a return order, even if there are ongoing asylum proceedings. However, that order cannot be enforced or executed while an asylum claim is still pending or before an appeal is resolved. So the reason behind that, of course, you may think is obvious. It would respect both the Hague Convention's priority on expeditious return, set out in paragraph 70 to 73 of G&G, but it also respects the Refugee Convention's principle of non-refoulement. Now, as set out in paragraph 128 of G&G, the High Court would effectively be preempting the Secretary of State's decision on refugee status if a return order were made and implemented before she discharges her obligations to determine that issue. So the implementation of a return order made in the 1980 Hague Convention proceedings would deny also the applicant the right to have their claim for asylum determined by the actual determining authority. And so this is why, in effect, it's important for these cases to have priority treatment in their determination. This is not something that appears only in the 1980 Hague Convention, most notably Article 11, but it's also at Recital 11 of the 2005 Asylum Procedures Directive, which clarifies the need to determine asylum cases as soon as possible. Similarly, the immigration rules also stress the importance of concluding as soon as possible, of course, without prejudice to an adequate and complete examination. An asylum claim is not determined until the conclusion, however, of any appeal concerning that asylum claim. Now, my experience of asylum appeals is that this is not a swift process, regardless of what the guidance may encourage. There are often extensive delays arising from the need for expert evidence, but also the court, well, the parties as well as all of you may well be aware of the concerning nature of the court being overwhelmed with applications, of there being limited judiciary to hear applications, as well as any non-compliance with existing directions. The High Court does have the power, as all of you will know, to set aside its decision if an asylum claim is later successful. So G&G at paragraphs 165 to 177 set out 7 practical steps where there are related proceedings. So firstly, it's recommended to add the Secretary of State for the Home Department as an intervener to these proceedings. Adding them as a party was considered, but the question arose as to whether that would result in the court's decision becoming binding on them. As such, it was felt sufficient for them to be joined as an intervener to ensure that there's no trespass on her responsibilities in the asylum process. Secondly, to join the child as a party to the convention proceedings, and also ensure the asylum application papers are disclosed to the child's representative. Now, that will ensure a clear line of communication, it's hoped, between the courts and the Home Office. Thirdly, the Home Office to set up a specialist asylum team for such crossover cases. Fourthly, for the documents in the Hague Convention proceedings to ordinarily be made available to the Secretary of State for the Home Department. However, with respect to the 5th point, in terms of disclosure of asylum documents, the relevant legal framework is paragraph 3391A of the Immigration Rules, which transposes Article 22 of the Procedures Directive, but also the 2015 case of R v McGew, in which it was highlighted the need, particularly at paragraph 23, to balance the systemic importance of maintaining confidentiality in the asylum process, together with the applicant parents and the child's right to confidentiality in their asylum process. And that would be particularly against the left behind parents' rights under Articles 6 and 8 of the Convention on Human Rights. Now, for that balancing exercise, however, when considering disclosure of asylum documents, the most relevant factor will be whether the left behind parent in the Hague Convention proceedings is the alleged actor of persecution of the applicant in the asylum proceedings. And so there is an obligation on the legal representatives in Hague proceedings to consider the asylum documents and identify the additional information that isn't already detailed in the Hague Convention proceedings. And that will be, in effect, confidentiality of the additional information, which will then need to be balanced. 6, stress the importance of standard directions in Hague Convention proceedings where there is a parallel asylum claim. 7, in linked cases, it was important to consider assigning any asylum appeal or judicial review to a family division judge. So there are 2, I believe, specific judges who can deal with those. The High Court should also have oversight and be in a position to coordinate both proceedings until both have concluded. Now, an example of that would be if the Secretary of State refused a child refugee status, but the child then appeals to the first tier tribunal. So it'll then be a matter for the High Court judge to bring the matter urgently to the attention of the senior president of tribunals and of the Lord Chief Justice. And they'd request that a family division High Court judge then acts in the first tier tribunal. So what if it's a non-Hague Convention country? Now, obviously, we've already been through, and thanks again, James, for dealing with issues where it's a non-Hague Convention state. Return applications must rely on the inherent jurisdiction, the Child Abduction and Custody Act, but obviously with respect to Brussels II, that has now expired, but in cases pre-Brexit, if there are any still floating about, that's what we'd consider there. Now, courts still apply, however, as James has emphasised, the welfare principles, Section 1 of the Children Act, but it also must weigh into the balance, the practical enforceability, which again, I'm grateful to James for having gone over already. So the case of Re Y and K, which is highlighted there before you, that concerned Iranian national parents and their 2 children. They were aged 5 and 2. The children had lived their whole lives in Germany, but they were habitually resident there. They had no connection with England. The mother had an uncertain immigration future in England, and she appeared to have a more secure, although time-limited, immigration status in Germany. In August 2023, she was picked up by the UK Border Force during their Channel crossing and taken to an asylum processing centre. She applied for asylum for herself and the children. And once it was known that the father had made an application under the 1980 Hague Convention, the asylum claims were referred for expedited consideration. The mother's application for asylum was, however, deemed admissible the following November on the basis that she was in fact a national of an EU country, in that case, Germany. However, in the application form, the mother's nationality was recorded as Iranian. The word Iran was set out alongside the names of the dependent children, and so she subsequently applied for a judicial review of that decision. That took as far as January 2024 for that judicial review claim to be issued. And that was on the basis of it being inadmissible. The mother is not and never has been an EU national. She meets the test for exceptional circumstances, which the Secretary of State didn't consider. But also the evidence showed that the mother was or is the victim of trafficking and wasn't properly identified as such. Now, the father living in Germany did apply for the summary return of the children. The mother opposed that, saying they didn't have rights of custody in respect of the children in Germany. So the matter returned under the inherent jurisdiction. And then the mother raised allegations of domestic abuse. So the father's application for summary return, in conclusion, under the inherent jurisdiction, was actually refused in this case. The Secretary of State for the Home Department was invited twice to intervene, but declined to do so. And the return to Germany was not deemed in the children's best interests. The judge also acknowledged that future decisions about the immigration status and their right to remain in England may not in the end coincide with the court's welfare-based decision. And so really what that case sets out for you is the importance of the balancing exercise that the court must undertake when it's a non-Hague Convention state. That is what needs to be proven in respect of the children's best welfare interests. So you need to ensure that that evidence is there before the court when it's making that decision. I won't go into Re-O. I'm conscious James has already gone over that with you. He did introduce the case earlier concerning 2 children who were removed from Nigeria to England by their mother. Their father sought their return. It didn't have concurrent immigration proceedings, but it is important for consideration in non-Hague Convention cases where the court considers the child's home country over and above whether it's their habitual residence. So the starting point would usually be that it's best for the child to be returned to their home country and for parenting disputes to be resolved there. And so this is really just kind of a brief overview of the situation for you, where you've got an asylum claim pending. You'd effectively have to await the outcome for any enforcement of a return order. If a refugee claim has been granted, that decision would ordinarily have to be respected. You couldn't be returned under the principle of non-refoulement. If an asylum claim is refused, the first-tier decision may be considered, but it wouldn't bind any family decision. And then with respect to findings of fact, they can be persuasive. Obviously, they'd have to be based on the evidence, but again, they're not binding. It doesn't discharge the duty on the Secretary of State to be making their own independent inquiry. And where an asylum decision is refused, the first-tier tribunal's findings can be challenged or ignored if the family court finds contrary evidence. And just for your note, that's from paragraph 127 of G&G. Whilst findings in the 1980 Hague Convention proceedings are potentially relevant, they do not discharge the obligation on the Secretary of State, nor do they bind the Secretary of State. And then if we go on to the next slide, we'll look at the relevant guidance that's been issued since G&G. So in July 2021, the Home Office issued guidance to its staff. It brings about an expedited process for considering these linked cases. It creates a dedicated team which allocates the appropriate cases within the first 3 days of them being issued. It actively reviews them, or it intends to actively review cases within the first 4 to 20 days, and that's to identify any barriers to them concluding within the recommended 30 days. However, most notable delays do arise from the need for expert evidence. The family division would then be notified of any issues with respect to delay, and that's of course vital given the determination by the court. And so where it's apparent that the case concerns a party or a child who has made a protection claim or has been granted protection status, the court will give directions in accordance with Appendix 2 of the relevant guidance, which I'll come on to shortly. There are a number of directions that the parties will need to consider as per the guidance that has been issued. If we move on to the next slide. And so this is guidance from March 2023, when the President of the High Court provided this guidance largely based on the case of G&G. It provides instructions for courts and legal professionals on managing the specific challenges in dealing with such urgent cases. And there's a brief summary of those there with respect to them having to be completed in the 6 weeks, and that's by virtue of the family procedure rules. Of course, James touched already on the likelihood of that being the case. I'm sure all of us will be well aware of how often cases are also kept within the 26-week time limit, but as long as the guidance is there, we can say we're trying. So the relevant directions would be an order listing the matter for a hearing, for summary resolution, or in the alternative for further directions. That's no more than 7 days from the date on which any application is made. So at the first hearing on a without notice application, if that's the case, There must be a direction for service on the respondent, a notice confirming the respondent's address, and the timetabling of the final hearing prior to the expiration of the 6-week deadline will need to be directed as well. So that includes an appropriate time estimate for the hearing, incorporating judicial reading and judgment writing. So you really need to be on top of this when issuing those applications to try and keep things within that time limit. You also have to consider what injunctive orders can protect or certainly prevent the need for removal from the jurisdiction pending conclusion of proceedings. And then if we go on to Appendix 2 on the next slide. So that's attached to the same High Court guidance. So it's linked in the heading on the previous slide. But if you keep scrolling down to the guidance and to Appendix 2, that deals in effect where there are ongoing protection claims. So if it's known when you're issuing a child abduction case that a protection claim has been made, then you need to indicate that on the application form. It's not appropriate for a child abduction case involving any of these claims to be listed before a deputy High Court judge. So you really need to be on top of that when issuing the matter. And that brings us on to the issue of allocation of these proceedings. It must be to a named judge designated to deal with these cases. They must be allocated to the Home Office Asylum Expedited Team, which again is set out in the asylum, the asylum guidance on the previous slide. The respondent must also provide the court with the name and contact details of any legal representative retained by them in the protection claim. The Secretary of State, as I've highlighted, should be invited to intervene in the child abduction proceedings. And in the event that the protection claim itself is refused and certified as clearly unfounded, and that's pursuant to Section 94 of the 2002 Act, and the respondent or the child intends to lodge a judicial review application, if possible, the application for permission and the substantive hearing should be rolled up and heard no later than a specified date. And so again, this is all stressing the importance of keeping things within a dedicated timescale and dealt with as quickly as possible in the children's best welfare interests. Any application to withhold disclosure on the grounds that disclosure would damage the public interest must also be supported by evidence, and that's as per the Family Procedure Rules 21.3. And where the matter is listed for determination as to whether documents should be disclosed into proceedings, the court will then direct a statement from the Secretary of State for the Home Department to deal with those matters, including the right or duty claimed to withhold inspection and the grounds on which that right or duty is claimed. And so obviously it's important for both hands to be aware of what each are doing so that there's no first duplication, but also secondly, with respect to ensuring that the ideal decision is made for the child. So that brings us to the conclusion there. That's a brief overview of the situation when we've got ongoing asylum proceedings. Thank you very much.
Thank you, Rehab, and thank you, James. Those were very full. Both of you have been very, yes, you've both actually done a very full interpretation of what is going on at the moment. I have to say that listening to you both and looking at the principle that cases should be determined, the welfare determination should be decided in the country of a child's habitual residence, and the principle that it should be done swiftly. When we look at both what James has been telling us and particularly what Rehab has been telling us, it's difficult to know how how things can be decided swiftly, and it's difficult to know what is going to happen in cases with immigration crossover, especially given the present circumstances. And the importance of having access to immigration expertise, advice, knowledge in cases where there is a crossover. The only question I've got at the moment on the Q&A, and I think this is probably a question for you, Rehab, is if asylum or other indefinite leave to remain was granted in England for a parent, but not for the child, would this prevent the High Court from ordering the return of the child?
Thanks very much, Maggie. So it would really fully depend on the basis for the refugee claim and really whether the child was actually a dependent on that application. So it's kind of difficult to put a broad answer in respect of that, because it may be on the basis of two different situations. For example, a mother might be fleeing on the basis of some sexual incident or in terms of her gender, whereas any child might be on the basis of something else. It really does fully depend on the circumstances, and obviously whether it's a Hague Convention state or not. And the reason I say that is because obviously the court will be applying a different test subject to that, but the same balancing exercise would need to be undertaken. And the court would need to consider what documents it needs sight of before determining that issue.
Thank you. Now,
Right.
I don't...
Maggie, I just want to add something to it. I think,
yeah,
and Rehab will correct me if I'm wrong, as she's the immigration specialist, the asylum and indefinite leave to remain are different things. Is what
yeah.
I understand, is that the asylum is the barrier of non-refoulement, not the indefinite leave to remain. And I think it would be quite an interesting case, because you would have the grave risk of harm under a Hague case, because the child would be going back by itself, potentially, and the emotional harm that would have leaving behind potentially a primary carer. So I think that would be an argument potentially there to say why it would be difficult. And in respect of inherent jurisdiction, you've got the fact that it, again, primary carer slightly differently would all fall down onto that. So I think, in kind of, whilst there might not be a barrier as strict a barrier, it's going to make it very difficult to get the child back. But that's what I just wanted to add.
Thanks, James. And James, in your experience, how many cases do you think that we're going to need expert immigration advice in the future, given that, you know, things are changing very swiftly in terms of asylum rules, in terms of how things are dealt with?
I think it's something that people, it's just more and more aware of, and I think it's becoming more of an issue in like the amount of people travel around the world now and meet and travel and go move with a partner to a different country, and then they separate and someone's got a visa based on another. So Australia is a good example. There are a number of cases that come out when you have family will move over there. One wants to stay there, so that husband, let's say, has the job out there, so his visa's fine. The wife's British, they have a kid. Wife then flees back to the UK, and you in Australia try and say you need to come back to Australia. There is the issue is that they're no longer in a relationship. It gets complicated because that the wife's visa is based upon the relationship. So I think it will become more and more regular in that sort of like traveling sort of cases as well, because knowing what happens and so forth. So, and the other interesting one sometimes is visiting. It's hard enough for people to come and visit family under, as far as I understand, an immigration rules, like, why will you return? If you've got an abduction case and the child's staying here and you've got to travel from, let's say, Afghanistan, for example, if the Home Office said, how am I going to, they could say, we've got no exception or belief that you're ever going to return. So you're not visiting. So we're not going to give you a visa. So it becomes really complicated.
Yeah. So the question about whether a child is going to be able to see both parents in the future and have a relationship with both parents becomes very important, doesn't it?
Yes, especially in the inherent jurisdiction cases, because that would fall under the welfare checklist.
Yes.
You have to go through, yes.
Yeah. it would do. So I haven't got any further Q&As on the that have come up. I don't know whether anybody else wants to raise anything at this point in time. I have to say that, sorry, I'm going to.
I was just going to add one point, because I was thinking, listening to Rehab about experts and everything, how the difficulty we all have identifying the correct experts, and I think sometimes that is where it's useful. Again, like, we are as a chamber quite advantageous, because if we need immigration advice, we don't necessarily turn to our colleagues for that advice, because they might not be registered in that country, but because of their immigration nature and knowledge, they have the contacts that can get you an advice on immigration law in different countries, because they've had to do that in their cases before. And because it's not, and I think sometimes the error when people come and even I know our chambers, we do get inquiries occasionally of, can someone in your chambers give me an advice on this country? It's like, unless we're registered acting in that country, we can't. And that's always the fine tuning of finding the right expert. So I think that's quite useful, having people and a team that we have in the immigration team.
Well, it certainly is. And even if somebody in chambers can't provide that advice, they will signpost us to somebody who can provide that advice. So yes.
Just to add on to that, sorry to interrupt, Maggie. Obviously, it depends, of course, on the situation on the ground and the basis on which the application is brought, or the defence, certainly. Because if, for example, it arises from harm on the ground in a particular state, there is effectively a list of experts on the electronic immigration network who offer country guidance guidance. And so they really are professionals on the basis of a variety of situations on the ground, depending on the country. If, however, what you're looking for is legal advice on the actual state, then yes, it probably would be a matter of coming through chambers. But then separately, there's also the option of independent social workers, and then obviously a whole host of other types of experts, including medical, subject to, again, the basis of your application, if there are any mental health concerns in that case.
Thank you very much, because also it has to be right that somebody who can provide certain kinds of advice about certain countries are not going to be able to provide advice when there is an overlapping immigration case and a case under the in terms of abduction. I think you need to actually be very careful about that. And one thing that strikes me as I kind of listen to both of you, and is also about the one thing behind abduction, the one thing behind the Hague Convention was for swift returns. But there are, it seems to me, more and more cases where you're not going to have swift returns, and there are fights going on, or in the courts here, or it takes a long time to gather all the information in order to be able to have the hearings here. So I think it's not going to get any easier, is it?
No, and I think I was listening to Rehab talking about the guidance issued by the Supreme Court of how quickly and how easy it is to do immigration, to have the judges who are dual ticketed or have experience in both. I am aware that there's one, maybe two High Court judges have any experience in immigration law. They're very busy, and I feel like they would probably be going, why do they not ask us to come up with the guidance? Because we can say how quickly we can do things. And sometimes people are looking down, going, in an ideal world, 6 weeks would be great.
Yes, but in most cases it's not going to happen once you've got any contest, is it?
No,
not at all. Would the Hague Convention come into play if a stepmother has been granted asylum with the children as dependents, where the natural father has died in the UK, and the stepmother is requesting parental responsibility over the children? The natural mothers are outside the UK.
Maggie, no. I think it's kind of on a very simple
Yeah.
level. It's factually complex, but on a simple level, no, on the basis that the Hague Convention for Abduction only comes into action if the person, so for example, in that case, the mothers in another country are saying for the return of the child, potentially, but it gets also again more complicated. If the child's been here for too long, the Hague, there's a defense under the Hague. So it's not necessarily an abduction case. There are other issues in that, but
Yeah.
yes, I think this is part of the answer. So I think the answer simply is no.
I think that's right, and we've got the stepmother requesting PR over the children. So whether that is requesting that here or whatnot, I'm not entirely sure. But I think it's I think we'd need to know more details, wouldn't we, James?
Yes, and it's a conversation they can have. If they get contact with our clerks, we can try and answer it. But
Yeah.
I don't think we're in a position to answer it.
No, I don't know the answer to that one. But I have to say that there's lots of scenarios that come up in these cases where you don't know the answer straight away, do you? You read it and you actually have to either ask more questions, or you have to seek further advice from people who are expert in areas that we are not necessarily expert in. So yeah, no, it's yeah, right. Okay, well, I think that unless there's anything else that comes up, I think that perhaps we'll leave that there for this evening. Thank you very much, both of you, because I think that that was very interesting. And I suspect that it might give rise to further questions as we think about things. And as James says, well, please come back to us through the clerks. Please do, because we're very happy to discuss things with everybody, with solicitors and other advisors. So please do that. And thank you for coming this evening.